a South African perspective. Okay, we just need to understand also from the onset that what we will discuss here will not necessarily cover every situation that you come across, but it's a general overview that gives guidelines as to what are the provisions of the law and what are your rights, what are your obligations, and how are things handled when those times come, the unpleasant consequences such as divorce, such as death. They're inevitable, and as unpleasant as it is in a Christian setup, we need to make provision for those kind of situations arising. So I'm not sure, I don't know if Arthur is already in. Laura, do you know?
Not yet. He got the wrong link, so we're just trying to give him the right link, and then he'll be with us shortly. Bear with us, just 2 minutes. Thank you.
Just send me a private message once he's in, because there's some things that are bouncing off each other. Okay, so I'm going to be sharing a PowerPoint presentation, and as we go through it, just allow me to go through the presentation and we can pose questions. If you have a question on any of the slides, just note what number slide it is or what topic it's under. And then when the opportunity arises for us to go into questions, I will allow that. I'll also pause if there is reason to make emphasis on a particular point or to just raise common questions arising from a particular issue from our experience. Just a bit of a background in terms of my experience. I studied law in South Africa, trained in South Africa, and I have been practicing in South Africa. I'm currently a practicing attorney, and I have been exposed to the types of matters that we're going to be discussing today. It's generally family law, but it's also looking at wills, estates, and things like that. So I will now begin with the screen sharing. Okay, is my screen visible?
I can see it.
Okay, so this is the South African legal position. South Africa has 3 types of marriages that it recognizes. There's what is called a civil marriage. This is a marriage between a man and a woman, which is formalized by signature, either the Home Affairs or solemnized by a marriage officer. This can be in a religious setup, such as the church. I will limit our discussion to civil marriages between men and women on the assumption that this is what we believe as Adventists, and this is what we practice. Civil unions are a union, it's a type of marriage which can be between a man and a woman, but it can also be between same-sex couples. So as you know, South Africa has legalized gay marriages, so they can only marry into a civil union. A customary union is a union that is concluded in accordance with the indigenous African customary law. So this is where we have lobola being paid, the families meeting. There are specific formalities that have to be fulfilled in order for there to be a customary law. So if you're in South Africa and you decide to get married in South Africa, regardless of where you come from, these are the 3 options that are available to you. That is what is recognized by the law. A customary union has the additional requirement that because it is done in an informal setup, you then have to go and register it with the Home Affairs for it to be legally recognized. However, the non-registration of a customary union does not invalidate it. I'm sure you're familiar with a lot of matters that have come to the courts where in the event of death, maybe a spouse is fighting to have their marriage recognized, and then the argument comes that, no, we never registered it. That alone does not invalidate a customary union. So on this aspect alone, I can say we have similar types of marriages even across the border in Zimbabwe and in Zambia. However, in Zimbabwe, we don't yet have legalized same-sex couple marriages. and I do not think Zambia has. I stand to be corrected. If anybody has knowledge on that, you can share. But anyway, it's irrelevant to this discussion. Okay. And then our matrimonial regimes are as follows. In South Africa, your default regime is the in-community of property. This means that a couple owns everything, all the assets that they have, they own in equal portions. It's 50-50, regardless of whoever's name is appearing on the asset. So even your bank accounts, it's in my name, but it also belongs, the funds in my bank account also belong to my husband if we are married in community of property. If we buy a house, whether or not I have my spouse's name registered on the deeds, the fact that I am married in community of property with him means that he's a 50% owner of that property, okay? If you don't want an in-community of property, you have to register what is called a prenuptial contract if you do it before the marriage, or an antenuptial contract if you do it after the marriage. So if we decide that we're getting married next week, our prenuptial contract must have been registered at least 3 months before the date that we actually sign at the Home Affairs. If the wedding date comes and we sign and we don't have a prenup, we are married in community of property. If we want to change that, we are going to enter into an antenuptial contract, which is after the wedding date, and it will also be registered against our marriage. It will be at the deeds office, it will be at the Home Affairs office. So just like I've explained, the assets that we talk about, which is called the joint estate, it includes assets that were acquired before the marriage was concluded, assets that are acquired during the marriage, assets that are acquired during separation. Even if you're waiting for a divorce, the assets that you get, as long as you are still married, those assets will form part of the joint estate, and we own it in equal portions of 50%, 50%. And then we have to make sure we understand this. These assets we're referring to do not include property that is specifically excluded from community of property in terms of a will or a trust or any other valid bequest. So this is what usually happens. I can inherit property from my father, but my father would have specified in the will that I am leaving this house to my daughter, Shungu. However, this property is not subject to any community of property. It means it will not form part of my joint estate with my husband. The same thing can happen in a trust where the founder of the trust specifically states that this property is for the benefit of my beneficiaries, and my beneficiaries will not, this property will not form part of any joint estate or community of property. I hope that's clear. And then what happens within community of property and testation? When we talk about testation, we are talking about a will. So what happens in the wills? When a party is married in community of property and they draft a will, they can only bequeath that which they own. So in other words, you can only give what you own. You cannot give what you do not own. So going back to the example I just gave, if I have an asset which I was given in terms of an inheritance, or of which I'm a beneficiary in terms of a trust, when my husband writes a will, he cannot include that property because he does not own it. It does not form part of the joint estate. So we are married in community of property, yes. I have property that I inherited from my father or from a trust. My husband cannot include that property to give away because it's not his to give away. He can only limit himself to the 50% that he's entitled to by virtue of our marriage in community of property. So, where A and B are married in community of property and own an immovable property, let's say a house or land, A can only bequeath his 50% share to his beneficiaries or to his heirs. The other 50% remains the property of the other spouse to do as he or she wishes. A can also specify that he bequeaths his 50% share to his wife. So this is a couple, even if they've got children, a couple can choose to inherit from each other. So I give everything of mine to my husband and my husband does the same to me. So whoever passes on first is giving his 50% share to the other spouse. And then after my passing, that means my spouse will have 100% of what we had as the joint estate. They will then decide what to do with it. The logical thing would be to give it to children if we have children. And if not, then he looks to whoever he wants to give to. And again, he must draft a will for that to be done. So it's important to note that it's not an automatic thing that a spouse inherits the spouse's share. If there's no provision in the will for me to inherit my husband's share upon his death, then I do not get it. It goes to whoever he has decided to give it to, regardless of the fact that we are married in community of property. But what happens is that I still get my 50% share before anything else, before his part can be given to anyone else, because he has a right to give away whatever to whoever he wants to give his 50% share. In the event that you die without a will, there's a particular formula that is applied to calculate who gets what. So if there's a spouse and children, the spouse is entitled to get 250,000 or a child's share, whichever is the greater of the two. A child's share is calculated by dividing the number of children plus 1 into the value of the estate. So let's say, for example, we have 3 children. The value of this estate is 2 million. A child's share would be 3 plus 1, which is 4, into 2 million. So a child's share would be 500,000. So because 500,000 is greater than 250,000, the wife who has lost a husband who did not have a will get 250,000 up front. And this 250,000, sorry, I made a mistake. The wife will get 500,000 because they've got 3 children. We calculated child's share. The wife gets the 500,000 from the estate. If there are no children and there's no will, everything goes to the spouse, not to the parents, not to the siblings, not to any other relatives. Okay, so it's only the spouse, and the spouse is not sharing with children where there are no children. So, I know in our Black culture, especially where I come from, there's a lot of stories where the siblings, especially when the husband passes on, the sibling comes, they want to take over everything and leave the daughter-in-law with nothing. That is not fair. That is not legal. That is not how the law works. There's a valid marriage. There's no will. You inherit from your spouse, but whether it's in community or out of community, when there's no will, you inherit from them. And then a child who is born out of wedlock is entitled to a parent's inheritance, whether it's a child of the husband, whether it's the child of the wife. If the husband dies and they have a child who was born out of wedlock, that child is entitled to get a share, just like the children of the current spouse. If the wife dies and she has a child from a previous relationship, or God forbid, another relationship that occurred during the marriage, that child is also entitled to their share of their parents' estate. And then where there's a dispute of whether this really is their child or not, that is resolved by DNA test, will be established relationship. Then in community of, let's just finish up the interstate succession. In the event that the deceased was not married, for example, maybe they married and divorced, or they never married, then there's no children, but he has parents, then his parents can inherit from him. If there are no parents, no children, no spouse, then siblings can inherit in equal portions. If one of the siblings has passed away but left children, those children will inherit the portion that their father or mother would have had and then divide equally amongst themselves. So if one of my brothers has passed on and left 2 children, and I don't have any children, no spouse, and our parents are late, those children are entitled to get whatever their father would have had if he was alive, and then they divide it amongst themselves equally. So the order of preference when it comes to inheritance in interstate succession is first is the spouse, then is the children, then is the parents, then the siblings are last. I think I'll pose, if there are any questions at this point, if you can direct them here. Are there any questions? Yes, I see a hand, Mr. Mtembo.
Okay, so the question I had, if you are married in community of property and the one spouse passes away and there is no will, you told us there's a formula that gets applied to a monetary value. What if they are fixed assets? What happens in the case they are fixed assets?
So the fixed assets are reduced to, when we do interstate succession and we're winding up the estate, the fixed assets are reduced to a monetary value, right? So that we determine who gets what. So the master appoints evaluators, independent evaluators, who then go and evaluate the property and put a value to the property. So it's up to the beneficiaries or the heirs to decide what to do with the property. Are they going to sell the property and divide the money that they get from it? Or are they going to each get registered as equal owners at the deeds office? Because then you have to go and amend at the deeds office to say now they're new owners. Mr. Mtembo has passed away, his 3 girls are inheriting the houses. Each one gets a third. So it's a decision that the beneficiaries must make. So it's not money, but that's money, the calculation of who gets what is still based on the value of whatever property that you've left. So if the house is worth, let's say $1 million, and Mrs. Mtembo is still alive, she first gets, and you're married in community of property, the first half of that house is hers automatically. From the 50% remaining, you calculate a child's share. In your case, it will be your 3 girls plus 1 is 4 into 1 million, because that's the 50% you're entitled to if your house is worth 2 million. Are you answered?
Yes, I am. Thank you.
Okay. Any other question? I don't see any hands. Okay, so we're going to continue.
Sorry, Shungu, I might have missed the first part on how do you then know, some of us might have been married blindly. How do you know you're married in community of property or out of community of property?
Okay,
because
so that is
for some it was love and they got married.
okay. We assume it was love for everyone. Okay, so at the onset of the question is dependent on where did you get married? What is the law in the country in which you got married? So, like I said at the beginning, I'm talking from the South African perspective. In South Africa, if you get married with no prenup, it's an in-community of property. If you got married in Zambia, it's also in community of property, default. You have no prenup, it's in community of property. If you got married in Zimbabwe, however, the default system is out of community of property. Each person owns what they came with and they live with what they came with. But my brother will get into it, Arthur will get into it a little bit more later. But that is you look at what does the country in which you got married say about the systems of marriage. So if you wanted an out of community of property marriage in South Africa, you're supposed to register a prenup. If you wanted in community of property marriage in Zimbabwe, then you were supposed to also register a prenup. I don't know how that process is done, but because their default system is out of community of property. I answered, Laura.
Yes, thank you.
Okay. So I'm going to move on. Sorry?
Just a question. Sorry, someone made me a call, so I can't raise up my hand. Sorry about that.
It's okay.
Just a quick question.
Yeah.
Is there something called a post-nuptial?
Yes. When we're saying antenuptial, it's the same as post-nuptial. So this is where a couple decides after they've already gotten married that, no, actually we want to change our marital regime. We don't like this. Or for whatever reason, maybe you're getting into business or you think it's better to split your estate in a particular manner. You can go and then go through the process of registering a post-nup or antenuptial contract. We call it an antenuptial contract in South Africa. Sorry?
Okay.
It's a whole process. It's a very expensive and lengthy process, because then you have to prove to the High Court that nobody's going to be prejudiced by your changing from prenup from one marital regime to another. So you also then have to publish in the local newspaper so that all your creditors are made aware, and any other interested party is made aware that this is what you're now planning to do.
Thank you very much.
Okay.
So can I ask a question? Can you hear me?
Yes, I can.
Okay, so let's say you're married in Zimbabwe, right? With that one which is out of community of property. But then, we're all now staying here and people are accumulating property. How does that work? Which law would then take precedence? Is it still the Zimbabwe one? Is it the South Africa one?
Okay.
How do you work
at which stage are you referring? Because we have death, we've got divorce, and it's different for both. So when it's death, the estate is managed by the country in which the assets are located, right? So you die in South Africa, you've got property in South Africa. Your property in South Africa will be wound up by the master of the High Court in South Africa. So they will apply the South African law. They look at your marital regime, you're married out of community of property. They apply their rules for out of community of property to wind up your estate. If you divorce, I'm going to get into divorce now, so your question might be answered in the following slides. So in terms of death, it's dependent on the country in which the assets are located. If you die in South Africa, but you've got property in Zimbabwe, the estate in Zimbabwe will be wound up by the master of the High Court in Zimbabwe in accordance with Zimbabwean law. So if you've got a will, you present the will to the master. If there is no will, they do it according to the laws of Zimbabwe. Joy?
Hi, thank you. Yes.
I answered. I think the other part of your answer will come in the following slides, because I'm now going to get into divorce. Okay. So when we divorce and you are married in community of property, ordinarily spouses split assets 50% each. So we had a house and it's worth 2 million at the date of divorce. If we don't want to enter into a settlement agreement where we say, okay, husband, you stay in the house, I'll move out to another house, you pay me out my share, then we have to sell the house and divide the proceeds in two. If the house is paid up, that means whatever you get is yours. If the house is still owing in terms of a mortgage bond, first you settle the bank. If there's any residue left, that's what you split between the two of you. But it's a 50-50. So if the parties in an community of property cannot agree how to split assets on divorce, then the court intervenes and they can make an order as to how the joint estate should be divided. The order that the court will make is in accordance to what is seen as just and fair. They'll look at both your demands. Okay, you're saying you want to stay in the house because you've got small children, you don't want to relocate them elsewhere, and this guy can afford to buy another property, or there's the option of getting into another smaller property because he's staying on his own. The court will consider both sides and do that which is equitable. That's on divorce of an in-community of property marriage. The parties will need to disclose all their assets and agree on how to split those assets. Bank accounts must be disclosed, company shareholdings, whatever business financial interests you have out there must be disclosed. If the other spouse feels that the other one is concealing information or withholding information that affects the division of the estate, then they can bring that to the court's attention. The court can decide to appoint a liquidator or an investigator, a forensic investigator, to find out what assets are being concealed, and everything is put together, and then the court will still make a decision on your behalf since you'll have failed to agree. Okay, so now I'm going to move on to marriage out of community of property. But before I do that, I think I must also give a chance to any other questions arising from in community of property. Mr. Mtembu.
My question has to deal with where you're married in Zimbabwe. If you're married out of community of property. Sometimes when you do transactions in South Africa, it seems to be almost like they assume you are married in community. So the court in South Africa, does it recognize that Zimbabweans are married out of community of property in their decisions? Or do they also make an assumption that it's in community of property?
Okay, so I was hoping no one would raise this question because this has actually become a topical issue within the courts, because traditionally they've been treating it as the way Mr. Mtembu is explaining. They assume that it's in community of property because it's a foreign marriage. But the law is very specific in its application. When you divorce, regardless of where you divorce, the law that should apply is the law which applies to the country in which you were based, the country in which your marriage contract was signed. The courts are supposed to actually get someone who is an expert in Zimbabwean law or who is well-versed, or even an attorney from Zimbabwe, to come and interpret the law for them, to say this is how out of community of property works upon divorce. This is how the marital regime works. That's what's supposed to be done. That's what's on paper. The unfortunate thing is that most courts are bypassing that, and they are taking any foreign marriage as an in community of property, and they make the orders. Sometimes it's fair, because when you're going to see as we go into the marriage out of community of property, that at its extreme, marriage out of community of property works only for one party in the marriage, because it's very rare that you're at equal levels financially at any given point. So I think there hasn't been that much of an outcry because, well, you know, it works out fairly, or the parties are just fed up of each other. They just decide, you know what, we're not going to fight this. But in the matters that I've done, where it's a Zimbabwean couple that is divorcing, or a couple from any other jurisdiction where their default system is out of community of property, we have stated upfront that this is a marriage out of community of property. Therefore, the way it is supposed to be dissolved is this way. This is what our client had. This is what the other client had. But maybe they're asking for a redistribution, or they're asking to say, you know, let's split it in a different way. So that is when the couple settles. But if the couple fights and they cannot agree, the law must be applied in its strictest form, or the court can intervene only to bring about a sense of fairness between the parties. Are you answered, Mr. Mtembu?
Yes, thank you, I'm answered.
And I think while we are on that, I've noticed also when you purchase property, there's a column that says foreign marriage, right? And the moment you state that it's foreign marriage on the papers for ownership. Can you still hear me? Hello?
Now we can hear you.
Breaking, dear.
Okay.
You were breaking earlier.
Yeah, it just showed me now that my connection is unstable. Okay. So I was saying that I've noticed that when you apply for when you purchase immovable property and you apply for mortgage, I'm getting feedback. So when you apply for a bond or you apply for financing, the way the forms are made is it's that the moment they pick up that you've got a foreign marriage, they take it as by default, then it's incommutive property. Then everything that follows is treated as if it's an incommutive property marriage. It's fine if it works for you in that now you become 50-50 owners. But in a situation where the couple does not intend to buy the property that way and intends for the property to be in one person's name and not the others, then it can create problems in the future. So you always need to be very cognizant of how you sign your papers when you're purchasing property, when you're getting into any kind of transactions, to be specific that this is a marriage out of commutative property if you're married in Zimbabwe. Okay. So now I'm going to touch on marriage out of commutative property. We've got up to 8 o'clock, right, Laura? Hello.
Hi. Yes, you can go on. You can proceed.
Okay.
It's unlimited.
So marriage out of commutative property is provided for. Okay. So the marriage out of commutative property is provided for in terms of the same acts that I mentioned at the beginning, is the Civil Unions Act and the Civil Marriages Act. You can choose how you want your out of commutative property to be there, because there are variations of how you're going to make it. We are not going to get into that, but what it suffices to state is this: out of commutative, which is what the Zimbabwean default system is, basically means if I come into a marriage with my suitcase of clothes and a bank account that I receive my salary in, and I get married to a man who has a house, 2 cars, a farm, and whatever else. When the marriage ends, be it by divorce or by death, I am left with my suitcase and whatever else I acquired during the marriage. That's what's mine. But the guy who came in with his house, his farm, his 2 cars, and whatever else he got during the course of the marriage, those things belong to him still. So in terms of ownership, each person owns that which they bought and registered in their own names as their assets. Okay. So if you want to prove your ownership of anything, you produce the receipts. You show us this is the deeds document and it's got my name there. Therefore, I'm the owner. If you're married out of commutative property, you decide to buy a property together, which you own 50-50, then both of you must appear on the title deed. So that example I've already touched on. So the out of commutative property regime, the popular one that they choose in South Africa is the one that is called out of commutative property with accrual. This one means that during the marriage, our estates grow separately. By the time we divorce, if it comes to that, the one whose estate has grown bigger than the other is forced to share 50% of the value of the growth with the one whose estate has not grown as much. Okay? So just to illustrate it, if A's estate is 50,000 at the date of marriage and B is 0, at the end of the marriage, B's estate is valued now at 200,000. A will be entitled to 100,000. 100,000 of B's estate, which is 50% of the growth of his value. Okay, no, I think I got my maths wrong here. If B's estate is valued at 200,000, the difference between the start value and the end value is actually 150,000, right? So if by the end of the marriage, B's estate is still 0 and A's has grown to 200,000, A will be entitled to 75,000. So, okay, before we go into those ones, into the slide, in an out of community of property with accrual system, you are able to get a percentage, it's 50% of the value of the growth of the other partner whose estate has grown bigger during the subsistence of the marriage. So it's sort of to level the playing field, because the argument usually is that in a case where one partner is out there making the money, the other partner is also playing a role in the marriage and in your acquisition of property, in that they're then looking after the home, bearing children, or taking care of the home, doing whatever it is, and supporting you to get whatever you then get during the course of the marriage. So it's only fair that at the end of it, if you then divorce, she does get something. So while her contribution is not monetary, it's of a value that can be allocated to her at the end of the marriage. And then if there is death, a spouse to a partner married out of community of property only gets what belongs to her unless there's a will stating that she will inherit from the spouse. Or if there are no children born of the marriage. And I think my brother Arthur will get into that in more detail. It's against also the backdrop of a very interesting case that was decided in Zimbabwe early this year, where there was a stepson and a mother involved, and they were arguing over property that was left by the father, who had specified in his will that I'm giving 50% of this house to my son, who was not his wife's child. So if there are children born of the marriage and there's no will, the wife will inherit a child's share, which is 250,000, or whichever is, she'll inherit 250,000 or whichever is greater. This is in South Africa now. I hope I'm not confusing you because I keep referring back to Zim. Okay. I'm just going to wrap up so that I give the remaining minutes to questions. Just a few tips to remember. You must know what marital regime governs your marriage. You must know what you own. You must know what your spouse owns. You must also know the debts that are owed to the estate, that are owed by the estate. What do you owe the bank for your property? What loans have you taken out? How much is owed? In the event that one of us passes on, or if we divorce, you need to know what exactly you own. And what you own is what you owe deducts from what you own, basically. And if you suspect that your spouse has secret assets in his or her name, first, of course, ask. If you're not satisfied with the response, check with the deeds office. In South Africa, you can get a conveyancer to do that for you. There's various databases where you just enter the passport number or the ID number, and it will show you what assets that person owns. If needs be, the extreme case would be to get an investigator to check what assets your spouse has that they might be concealing from you. And you must draw up a will stating exactly what you wish to happen to your assets. And you must give details even of small things we take it for granted. Where you want to be buried, how you want to be buried, particularly those of us who are not in their home countries, because we know the tradition is that if I am to pass on here, people will probably most probably insist that I be buried in Zimbabwe because that's my home country. But I might feel differently. I feel maybe the expense is not worth it. I'm dead. My children are going to be here probably for the rest of their lives. My spouse is here, maybe even married a South African spouse. Specify that in your will and state that I will be buried in South Africa or in whatever country I'm residing at that time, or my wife or my husband will decide where I am going to be buried. That eliminates a lot of problems within the family. Be transparent about children from previous relationships and children born out of extramarital affairs, because those children are entitled to inherit from you and to receive maintenance even after your death. Be transparent about financial affairs, business partners, any other affairs that might affect the estate. And most of all, seek guidance from the author of the marriage institution, and that is God. With all the worldly knowledge and without spiritual guidance, your soul will still be lost even after you know all these interesting things. And that reminds me of the verse, Matthew 6, verse 33. Seek first the kingdom of God. All these things will be added unto you, including the wisdom of how to get married. Well, it's too late for us, we're already married, but the wisdom of what to do in terms of how you plan your estate and how you get your marriage to be the particular regime you want, which works for your circumstances. That's the end of my presentation. I am going to give it back to Laura. Do we have time for questions?
Shungu. Yes, we do have time for questions. We can squeeze in questions, but you wanted Arthur to...
Is he in now?
Yes, he's been in for a while.
Oh, okay. All right. Arthur, I don't know if there's any contribution you want to come in and touch on at this stage.
I think pretty much you've done all the work, eh? Just of course, I'll just add one or two things in terms of the recent developments. But I think your presentation was really splendid, and I really learned a lot of things. At least we guys in Zimbabwe are safe. We get into marriage with our assets.
I don't know about that. I don't know if the wives feel the same way.
You know, someone asked me one question. He says, dude, can I just marry a rich guy, then divorce and get their assets 50-50? And I said, in Zoom, you can't do that.
Not in Zimbabwe, no.
No, you can't. So since 1929, all marriages are now out of community of property. That's the position in Zimbabwe. So before 1929 and the Matrimonial Causes Act, we used to have quite a number of things in terms of the matrimonial law. You used to have the fault principle, and the marriages then used to be in community of property. So I think that change is quite fundamental in respect of many things. I think, Shunga, we're talking about that in terms of divorce, mainly. If it's out of community for property, you are talking about his, hers, and pretty much theirs. What did they gather during their marriage? And it also even has implications in terms of when the other spouse incurs obligations. There is a decided case where the husband incurred an obligation and had 50%. They were jointly registered on the property. And the creditor came to attach the 50% of the husband. So you know what happens? If the 50% in your house is attached, what that literally means is it can be sold and you can stay with it in the same house. So the wife was saying, guys, it's not fair, blah, 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 blah. And obviously that argument was not successful. So it has serious implications. And I think one of the things that Shung was mentioning is the latest clarification by the Supreme Court in terms of what happens to spouses who are married in community of property insofar as the issue of disinheritance is concerned. And I think the subject of disinheritance is very uncomfortable. In Zimbabwe, you are allowed if you are married out of community of property. So we've got 3 types of marriages in Zimbabwe. I think pretty much what Shunga was talking about, the difference is we don't recognize same-sex marriages. There is nothing like that. So the first default is usually when these guys go and leave Mombe, I don't know what you call them in South Africa, and you pay whatever you pay, we call it lobola and so forth. So that is usually what is called an registered customary law union. It's not a marriage in terms of the law. It's only recognized as a marriage for purpose of inheritance and for purpose of maintenance. that's when it's recognized as a marriage. Then the second type, of course, in no order of particular importance, is the African customary marriage, which is your chapter 5.07, which allows a man to have more than one wife. That type of marriage causes a lot of worry to many women, pretty much, because once you enter into that, even if you find your husband with someone else, you can't even sue for adultery. I know in South Africa, you got adultery damages. So obviously, a conversation around moving towards that particular direction. So if your husband is seen with another woman, you just have to appreciate that he's trying to have a second wife. So you have cause of action in terms of adultery. That's your African customary marriage. So what happens in terms of the first two, these are in community of property. So the husband pretty much has got power over the property. So during the tenure of the marriage, the power of the husband entitles him to administer the estate in the manner that he deems fit. So a number of times, many women have been finding themselves in a very vulnerable state because of the marital power of the husband. So you can sell the property, you don't sue him, you can dispose of it anyhow. You won't sue. Obviously, in terms of the law, there have been quite some interventions in terms of some common law remedies. So the third type, which is pretty much what people call church wedding, it's actually not a church wedding, it's your civil marriage. So in civil marriage, that's chapter 5.11, which is by operation of that intervention in 1929 by the Married Persons Property Act of 1929. It's out of community of property. So once we get married, the question is, what did you own at the time of marriage? And now the usual conversation is in what did you bring, what didn't you bring? Then now you find in terms of the divorce cases, depending of course with the courts that's really sitting on that issue, sometimes that out of community element has not been respected much. So sometimes some of the judgments that you read, they're literally sounding like you're in community of property. Because in terms of the Matrimonial Causes Act, the court is allowed to even take property that you actually owned before you got married and to give it to the other spouse. Because the court is given the power to transfer property from one spouse to another, meaning the property that you actually bought as a bachelor can be transferred to your spouse in the process of trying to distribute whatever estate that you have. So that's the bit of drama in terms of in terms of the marriages. And so in community of property, when it comes to inheritance, the law allows parties who are married out of community of property. The law allows parties who are married out of community of property to disinherit each other. I need to repeat this. You are allowed, if you're married in Zimbabwe, out of community of property, to disinherit. So what it simply means is, even if we're jointly registered on property, our matrimonial home, I'm 50% owner of the share of the property. So once you are jointly registered on entitled deed, the assumption is 50-50. That's the legal assumption. So you're allowed to give that 50% in your will to whoever that you want.
Someone else,
even though they are not your spouse. That's your Gwada judgment. So effectively what the court is simply recognized is the rights of the parties who are married out of community of property, that they are free to deal with their estate in the way that they want, which to me absolutely makes sense. Because if during your time, if you're alive, you're allowed to actually dispose of a particular property with no interdict coming your way, I don't think the position should change simply because someone is no more. So I really think that position makes a lot of sense. And pretty much when it comes to the issues to do with your estate, it's absolutely within your discretion insofar as it's within the bounds.
Up to you.
Yeah. So one of the things we need to emphasize, of course, for those who are married in Zim, you can disinherit, but there is an obligation to maintain, especially if you've got children who are below the age of 18. There is an obligation to maintain your children. So you might need to make provision for maintenance if you are planning on disinheriting anybody, so that you don't have your will being challenged and so forth. So for those who are not married out of community of property, the default position is pretty much what is governed in terms of your Administration of Estates Act. So there is a distribution plan that works. But mainly, if you're actually married in community setup, which is the default, the spouse, you get the concept of a surviving spouse, where the surviving spouse pretty much is inheriting together with our children, which is why I think it's also very important for everybody to get great time to sit down and write a will. Guys, if you can write a WhatsApp message, I think you should be serious enough to write a will. It doesn't take hours to have a will in place. If you are lazy, you can go on internet right now. You can go on the internet before going to check what's on Facebook. You can download a template to use to write a basic will and to ensure that your things are in order. You see, one of the things that I find very disturbing is prominent people, including lawyers, dying interstate. It's really disturbing. Very, very prominent people in society dying interstate. And the majority of the times that families are actually fighting over properties. The Bible says a good man leaves an inheritance for his children's children. That ability to leave an inheritance also means you've worked, you've gathered assets. You should be able to ensure that you pass on the legacy to the next generation. And I really want to encourage anybody. We're praying so much because we want to go to heaven, want to go to paradise, etc. But you're not going to go alive. Are you with me? You have to die first. And because you have to die first, it also means you're going to leave affairs here. So we might as well be that serious to ensure that we sort our affairs. And the moment when we die, let's not leave a chaotic situation. I think I like what Shungu was talking about, issues to do with the burial, etc. No offense here, and I know the sensitivity of this. But in Zimbabwe, with some guys who got bent in a car, I think some of you guys were following that story, and issues to do with the burial of a person had to be decided by the High Court. Imagine that complexity where we don't know how to bury you, we don't even know how to deal with your remains, which is something that could have been resolved just one page, saying in the event that I'm no more, the two things that I have is going to go to my daughter. In the event that I die, I wish that my remains be buried XYZ, and don't waste your time doing 1, 2, 3 rituals. I wish my wishes to be honored. So guys, I really want to speak to anybody right now who has got funeral policy but doesn't have a will. That's a manifestation of lack of seriousness. That's a lack of seriousness. So you can't have a funeral cover, and on top of that, you don't have a will. It's not seriousness. It's just as like you want to live long and you don't have medical cover, you only have funeral cover. You see, those things, that's a manifestation of not being organized. So I really think we need to take this thing seriously. And for those people who are married, let's also take our marriages seriously. I don't think it's really proper to just go into marriage simply because of what you can get. I also think these conversations, Laura, should also extend to people who are single. Many people, they don't actually know what they're getting themselves into.
Yes.
Usually thinking they're going to a bedroom, then realize, no, it's just a bed. Then realize that, oh, I'm actually going into this relationship with a gold digger, particularly. So I really think it's very critical so that you also get to protect yourself. And things like anti-nuptial contracts are very important. I'm a Christian, by the way. I'm not saying people should divorce and so forth, but these things do actually happen. I've handled quite a number of these cases. Yeah. And trust me, I've had the privilege of seeing, it's not a good one, seeing a marriage after 40-something years, people saying, I'm tired. And the next thing is a battle. And people will really win in court, guys. It's not you, it's me, the lawyer, because you need to pay my fees, whether you win or not. So I really think it's important for our youths to be educated in terms of, guys, what are you getting yourself into? What are the obligations? What does it mean? Are you ready for this? And how do you get other options? If you actually know them, if you don't know them, please do this. So I really want to commend you guys for what you're doing in terms of empowering people. And unfortunately in Africa, we don't want to learn. The scary ones, they just want miracles. But I really think this is worth more than a miracle, where you get your mind opened, you get to be empowered, and you get to know, okay, how can I improve my life? How can I protect my assets? And guys, why it's also important for the out of community setup. You might be married to someone who is a spendthrift and who is always accruing obligations. That's why I think the portion is really better. I might as well defend my portion if my spouse is not very good in terms of not borrowing or just borrowing. I think that's why I really enjoy the out of community setup. It's really nice. So for those who want to join us, please get the anti-nuptial contract.
I think most of us are there just by looking at.
Yeah, so that's a bit of Zime. But my encouragement to everyone here who has got any asset, who has got children, go and write a will. If you don't have money, I said go online, look for a template before you sleep. I'm not saying you're dying tomorrow. I'm saying before you sleep, get a template.
Yeah.
Yes. Back to you.
I can also assist with that service. They all, yeah, I am offering that service. We can do a run on that. I also wanted to come in there in terms of wills, Arthur.
Yeah.
You've got the option to come as a couple and do what is called a joint will. South Africa has that provision. That way you're able to, number one, be transparent to each other about what you own, who owns what and whatever. And this is what we want to do as a couple. So your wills don't clash. So it's okay to have a joint will. There are administrative issues that, there's pros and cons to it. You can have a joint will, you can have separate wills. If you're going to have separate wills, have sight of the other's will so that your wills do not clash. You can die together in an accident and you've got separate wills which are speaking conflicting interests, you know what I'm saying? So have sight of each other's wills so that your estate is smoothly wound up in the event that you die simultaneously. Okay.
Yeah, and I think also, Shungo, it's also good for couples to trust each other. You see,
yeah, but
why some people are so uncomfortable to show you their will? Because some people think you'll mysteriously die. You see, and you done a very good will and said, sweetie, you're going to rule everything. It's so the next thing with some stomach ache which you can't explain. And you wake up in
which is, the fear that has been spread into most men, because there are actual cases here in South Africa where wives have killed their husbands just so that they can benefit. Remember, we are in community of property. So you die, you have no will, and the sole heir. So that's a fear, and it's a valid fear that some men have, that the moment I disclose what I have or what I have in store for her, then I will die. But we are trying to speak about it in the context of Adventist Christians. Let's have this God as your center of the marriage, and everything else revolving around that can only draw you closer to one another, and you make the best decisions for your estate, for your children, and for the heirs that will come after your children. So we just want to encourage that, spirit of, godliness, as couples. Let's trust each other enough to come up with something that's sustainable, not just for us, but for our children and going forward.
Yep.
Sorry, just to interject. So the invite and the seminar is not just for married couples. It's open-ended. It's for singles. It's for widows. It's for the young, because these are issues of life that will affect us at some point, either on dissolution or on wanting to get married, death, whatever it may be. So I also encourage the people that are listening to extend the word, to extend the invite to our youth so that they are better informed. Some of us have made decisions that we have to, live with, but they still have a chance to protect themselves. Then I have a question. Say we have a joint will. Then one spouse decides to have another will. Which one will take precedence?
Say you've got a joint will as a couple, and then the other party decides to draft another will.
Yes.
It's now a game of taking chances at the time of death. Who dies first and which will is recognized by the master? Because both of you have the capacity, and you've got, as long as it's a valid will. Oh, no, I'm wrong there. There's case law to the effect that you cannot have two wills that conflict in terms of its content. And if you have a will drafted but with the assistance of an attorney, most of the times there's a clause at the bottom which says, it's a cortical which says, I revoke all other previous wills made by me, what. So if there's a revocation clause in the more recent will, that means we're not going to consider what he said in that joint will. We'll consider what he says in this will. But still, the principle applies that you can only give what you own. So they cannot now then go and make a will, which is ultra-vires, which then gives things that do not belong to him. So a person married in community of property cannot now come and say, no, I'm giving my house to my mother, because 50% of that house is yours by virtue of marriage.
Yep.
So it's going to be a principles of justice question and legality.
Yeah. Also,
Also, I don't know if you want to explain it.
Guys, I think that also goes back to the issue of transparency. It's also good to tell a family that it have a will and not necessarily disclose the contents.
Yeah.
Yeah, so people can actually know the existence of a will, even where it can be found. It's also critical. A number of people have written wills and they are not found. Like I get people saying, no, my father did a will, but we don't know who the lawyer was. It's as good as he didn't write anything, because they can't use a will which they don't have. So I think it's very important to ensure that we make sufficient disclosures as to where our wills are. You can have it kept by a bank, you can have a lawyer do it for you, or somewhere safe. It's so critical. And also I want us to realize that the wills only start working when you're dead. And because it works when you're dead, it means it has to be prepared with a certain level of seriousness in terms of the packaging, the contents. And what makes a will valid is because it has been prepared in accordance with the law. Meaning you can actually waste your time and prepare something that is not going to be recognized. So I think it's very important to ensure that we prevent drama happening. And I think what has been explained by Shungo in terms of revocation clauses, it's pretty much a standard clause that's put in wills to ensure that in the event that you've done something elsewhere, it actually cures that by cancelling any other testamentary acts that you might have done. I think there's a hand from Mandy there.
Yeah. Yes, there's a hand, Mandy.
I just want to ask, how do you validate these wills? Because you're telling us to get a template online and write a will, but how do we validate it? How does it become valid?
All right, so if you're in Zimbabwe, once you sign it, is valid. Pretty much you need to have 2 witnesses signing. We need to ensure that it's you who has written it. Secondly, you need to sign every page so that those creative ones do not necessarily come through and create their own version, which is also beneficial to them. So it has to be signed and initialed on every page, just as security. Then obviously the final page is very critical. So the witnesses just have to be ages of 18, and that's enough. But if you enzyme additional security, you can actually lodge your will with the master. Then it's given a case number. So that moment when you are no more, and whoever you trust has got the reference to that will, they can actually go to the master, then you can have the process initiated. So it's not a complex process, eh? Once it's signed, witnessed, it's okay, it's valid, it's live, it becomes live.
After I've lodged it, can I change it?
Yes. You can change your will as many times as possible. So this guy, the story told, was deaf, and somehow he managed to recover the ability to hear, and he doesn't tell the family that I can hear. So imagine you stay with a person who all along you're thinking is deaf, but somehow he's actually hearing everything that you're saying. And suddenly he tells these guys that, guys, I can hear you. And he's asked, so how long have you been hearing? He says 7 years. And he says, what did you do ever since you recovered your sense of hearing? He says, I changed my will 7 times. And because, you know what, you've been hearing things that you never thought you'd hear. So the good news with the will, you can cancel it, you can revoke it, you can also amend it. But what I usually advise people, I think Shungo also advised the same, rather than scribble on your will, it's rather better to actually do a fresh will, which does not have some scribbled notes, because you see what, people always have issues. So it's better to actually have that. That's why the revocation clauses come through. So yeah, you can amend your will anytime. You can remove any person from being a beneficiary anytime without telling them and without even explaining why you're actually removing them. And by the way, disinheritance, you can also make it express so that someone will not think that they were forgotten. I've seen some people actually specifically provide that so and so shall not benefit anything from my estate. To me, I think it's actually better to actually say I'm not going to benefit anything. It enables us to know that this was not an error. You were left out. Yeah.
But better to put it in writing so that it's not a hearsay of he said, she said.
Yeah,
okay,
true.
I got a question here via the chat to ask if the ownership of property is already registered in one of the partners' names. How do we change it now? So there's two things. Look at your marital regime. If you're married in community of property, it's already by default, you're a 50% owner, whether or not your name is appearing on the title deed, right? But if you're married out of community of property, then you have to go through a conveyancer to add yourself as another owner to the property. So typically here in South Africa, you would approach a conveyancer. That is a specific type of attorney who deals in property law. You approach a conveyancer and you tell them, this is my wife. I just want her to be added as 50% owner to the property. They will go through with you throughout the whole process until they get the registration from the deeds office confirming that your wife is now a 50% owner of this property. If the property is based in Zim, you can go to Zim and find out. Maybe Arthur, you can also shed light on how they would treat a case like that. But the South African position is that you go to a conveyancer, they assist you, they do the necessary paperwork so that there's a split in the ownership on the property.
Yeah, true. So in Zim, if you're actually married in terms of chapter 5.11, it's actually easier. You don't even pay tax because there's no capital gains tax, because there's no gain, because you're transferring your 50% share to the other spouse. So as long as you're able to prove a valid marriage, it's, of course, you have to pay the other, your raise clearance and so forth, but it's something that can be done.
The simple process.
Yeah, but for estate planning events, I also recommend you should actually try to also set up family trusts. So to me, I also think it's actually a much better way to do things so that you are able to effectively put things in order
exactly.
in a much more visible and transparent way.
That's applicable here as well. I would also do the same.
So I usually advise people to go through the trust route, and obviously just have a will in place to cover other aspects that you may not specifically provide for in terms of the trust, like where you want to be buried, etc., and some other things that are of a personal nature. I really think it's something that we can also explore as part of our estate planning.
I don't know if there's anything else, Laura, from your end. I'm sensing a bit of a lull in the audience. I don't know if this means they clearly understand or they're more confused than when they came in. But
okay, there's a hand up.
Mr. Mtembo, is that him?
Yes.
Yes, Mr. Mtembo.
Yes, I've got the same question as Mrs. Manyama. You know, when you say trust to me, I think it's someone that a rich guy does to protect his things. How does it work for me? What is it? How does it work?
I can do it for you. You must come to me and consult. So, but basically, it's a very simple process. A document is drafted which explains the purpose of the trust. Well, the founder, the beneficiaries, the trustees. The trustees are the people that will be responsible for the administration of the trust. In South Africa, you have to have an independent trustee who's not a member of the family. We're talking specifically of family trusts. And this is deemed to be the person who will have a neutral position in terms of the decisions made around the transactions of the trust. So the lawyer will draft a deed of trust, get you to sign the necessary forms that are required by the Master of the High Court, and then they will go to the Master of the High Court and lodge that deed, and it will be registered as a trust in SA. In your trust, you specify who your beneficiaries are. If you want them to be your children, if you want them to be your children and their children, or your wife and their children, or yourself, you can also be a beneficiary. But it's basically a vehicle that distinguishes assets from your personal capacity and places it or vested in a trust so that that vehicle can even generate income from the assets that are vested in it for the benefit of those that are nominated as beneficiaries in the trust. it does not require any value of assets for you to have a trust. You can have a trust even without anything in the estate, and then you build up as you go. So it's just an estate planning vehicle which works to sort of remove you personally from the affairs of the trust and make provision for your children and whoever you want to nominate as a beneficiary.
Right, so I think I can come through here. So in Zim, we're not as complicated as you guys in South Africa. So what it simply means, so a trust in Zimbabwe, I don't know South African position, it has been defined as a legal arrangement. That's a trust. It's a legal arrangement where one person called a founder enters into an agreement with a second person called a trustee for the benefit of a third party called a beneficiary. That's a trust. So pretty much it's a tripartite arrangement where you're entering into that relationship with the second party, the trustee, for the benefit of a third party called a beneficiary. So in Zim, a trust is not a legal person, but it has capacity to own properties and it's recognized for legal processes, though it can institute proceedings in the name of the trustees. So registration in Zim is it's also quite simple. You prepare a document through a notary public called a notarial deed of trust.
Really?
Yes, a notarial deed of trust, a donation in trust. So you have to donate something, and that's what you get. So notarial deed of donation and trust. So that document is prepared by a notary public, and we need to know the properties that you're actually donating or to that trust. And once that is done, it has to be signed by the founder trustees, witnessed as well. Then the notary public also attests to the document. It's lodged in triplicate. And once it's lodged with the deeds registries, it's given an MA number, then yeah, you're good to go. So the difference in Zim is you can appoint even your family members to be members of your family trust. And that's why I actually think it's better, because I rather have someone I know also well-versed with family to run their affairs. So you can actually come up with that setup. To me, I think it's actually much more smarter to have a trust in place than additionally just have a will to speak to one or two things, and also just to avoid any confusion. So just having that relationship, to me, I think it makes a lot of sense. That's what I'm actually advising the majority of my clients. Yeah, Ms. Chipunzas.
All right, thank you. Mine is a long-winded question because, yeah, there's a bit of confusion on my side with regard to how the types of marriages work in conjunction with a will. I need to understand what supersedes what. So when Shungu started, she explained the types of marriages, right? And for us who are Zimbabweans living in South Africa, there is that complication that our marriages are actually out of community, right? But there's a twist that she also mentioned, which is that accrual part, which means that whatever we've accrued together will be split 50-50.
That's in South Africa. That's in South
Yes.
Africa. Yeah, I don't know if it's applicable in Zim.
Yes, so I'm a Zimbabwean living in South Africa. So perhaps I didn't quite get what you said earlier, that so in my case, in my husband and I's case, which law would apply to us in terms of what we are accruing here in South Africa? The reason I'm asking is that if it's the law of Zimbabwe that supersedes the one in South Africa, how can we then maybe make our arrangement more, should I say, transparent to everybody else, that we actually make it community of property rather than out of community of property, if that's what we want to do? And then secondly, when you actually then come up with a will, does it then supersede whatever you have, regardless of what type of marriage it is? In the sense that, say, for example, you are married in community of property, but your will then allows you or gives you the freedom to actually then appoint anybody else to inherit your property. So yeah, I just have a lot of questions, but maybe let's start there.
You're muted, Shungu.
Sorry. Okay, sorry. I was asking if Arthur can address the first part of Mrs. Chipunza's question. My understanding is that Mrs. Chipunza is married in Zimbabwe. Is that correct?
Yes.
Yes. So your marriage is
I think
registered
it's
in Zimbabwe.
chapter 37. Yes, it's registered in Zimbabwe. I think we had that chapter 37.
The chapter 511. If you're married in court, it's a 511.
511.
In church, okay. I mean, yeah.
All right, my Chipunza, if you don't mind, can you just
married in church, but still signed that.
Yeah. That makes it chapter 511. And what's
511.
I want to check what's the query so that I can be able to narrow down. So you are married in chapter 5.
So being based in South Africa and accruing maybe property and stuff here in South Africa.
Yep.
And knowing what we now know, because all this time we thought we were married in community of property. And now that we know that it's out of community, how do we actually make it? If we want, do we have an option to actually change it to in community of property so that it's just easier for us to handle our affairs and also maybe to protect our property basically?
Yeah, that is, yes, you can. So that's why, so there's prenup, that's before you marry, and an antenuptial, meaning after you get married, you can actually do an antenuptial contract to convert your marriage into an in-community of property setup. It's doable.
Okay, thank you.
Mrs. Chipunza, you asked about a will when you're married in community of property. Hello?
Then guys, one thing that hello. I think let me also clarify something here. A will does not supersede the provisions of the law. So a will does not change the rights that you have or the rights that you enjoy. Meaning you cannot give your estate away when you're married in community of property. You can only give your 50%. So even you are so excited and so forth that day, you're only limited to what you own. Meaning whatever that you write, a will can be validly challenged and set aside if it's not complying in terms of the law. And if it's taking away rights, you can properly attack it. And that portion can be nullified.
I see also another question on the chat. I don't know, Mrs. Chipunza, are you answered? I think I'll ask Laura.
Yes, which is comforting. Maybe that. So sorry.
You're breaking up on my side.
Hi. Am I breaking up?
Yes. I can't hear you.
Shungu, can you hear me?
Yes, every time you ask if I can hear or if you're breaking up, I've heard, but then there's silence. Mrs. Chipunza, are you speaking now?
Let me try it. No, I was quiet. I'm speaking right now. I don't know if you can hear me.
Now
so
I
maybe
can.
I can type. Now you can hear me.
You're breaking up.
All right, let me type on the chat so that I also give others a chance to ask questions.
Okay. I saw a question from, is it Larry, where you're asking if trusts are tax efficient. No, I can't find it. Are trusts tax efficient? It all depends on how you structure your finances. But I do find that they are more tax efficient than holding assets in your personal capacity. So I would say yes. But for greater detail on that, you would need a tax expert, which I am not. And then there was another question.
Hi, Shungu. Sorry.
Yes.
Larry, just to answer on the trust, just briefly an overview on the efficiencies of trust used to be very efficient in South Africa until SARS. You know, people used to hide things and whatever. So SARS has been looking into trusts and you know, putting laws on this and that. So it, like you said, it depends how you set up your structure, how you document your trust, how you not document, how you draft your trust deed, and how you work around it. So I would advise that you maybe see, or I can look for someone who can in our next presentations, maybe who can touch on the efficiencies of trust. But like you said, it's better than being in individual, in your personal capacity, because there are issues of security, there are issues of separating what you call separating
the personas.
Yes, the persona, all those things. So maybe we'll need someone who then will present you know, the efficiencies, I think we need to wrap up for today. We still have a session tomorrow, so we can carry over the questions and we will address them tomorrow. And I think Arthur needs to get to another meeting, and I think we're getting a bit exhausted. Yes, tired. So let's wrap up. I'll ask you, Shungu, to maybe wrap up, you and Arthur to wrap up, and then we'll meet again tomorrow.
Okay. All right. I just want to thank you guys for your presence and your participation. And even the questions that will come up later in your minds, feel free to bring them. We will make time to address them. My suggestion would be that you send your questions to Laura so that during the course of tomorrow, we can maybe look at them and see if we can't make specific provision to answer specifically. Also remember, we are giving an overview. Every matter is dealt with on its own merits. So everybody's situation will be unique. You might want to go and do a proper consultation with an attorney where you put your cards on the table and say, look, this is my situation, this is where we are, this is where we want to go, how do we do this? But at least now you've got a base to start from in terms of knowledge, that you have options available to you, and it's up to you which one to exercise. So on that note, I want to say thank you. And I hope that God blesses all our marriages. Those that are still planning to get married, make the right decisions for you. What works for one person might not work for the other person. Let's meet again tomorrow. And tomorrow, Arthur will be speaking more on estate planning. But I think we can just reserve a few minutes before we begin the session to answer questions arising from tonight's presentation. I'm going to close with a word of prayer. Let us pray. Our kind and loving Father in heaven, we thank you for this opportunity that you've allowed us to come together as your children and discuss matters that concern us and the law. We pray, Lord, that everything that has been spoken and learned today may make a difference in our lives for the better. We pray for all the homes that are represented here, all the couples, all the families. May you bless them in a special way. May you help everybody to achieve that which they wish to in terms of planning their lives and also in terms of having fruitful marriages. We thank you, Lord, and we ask for your presence from now and forevermore. In Jesus' name I pray, amen.
Just an update, Shungu.
Okay.
This goes to those who are single. For those who are single, it's not the choice of type of marriage that's important, it's the choice of a partner That's more important.
That's true.
I just wanted to clarify for those who are yet to get it.
And
Right.
yes, Mercy, it's a very uncomfortable conversation, but it has to be had. It's one of those things we must talk about as couples, but it's unpleasant. We don't want to think of divorce, we don't want to think of death, but reality is we have to. Yeah.
So thanks so much. Laura, thank you so much for the great work that you're doing. And
thank you, Laura.